It is estimated that from the late 1800s and through the early 20th century, 22 million immigrants entered the country through Ellis Island in New York. During this time, Ellis Island was the main entry point for those looking to immigrate to the United States. Immigrants were categorized based on health and physical ability. The Act of 1882 was the first major immigration law that targeted anyone considered to be a public charge. Those individuals considered to be a lunatic, idiot, or someone who could not take care of himself or herself were excluded immediately.
My name is Kristina Seil. I am an immigration attorney, and we are talking about the Immigration Act of 1882, one of the first Supreme Court cases wherein the Immigration Act of 1882 was interpreted. The public charge grounds of the Immigration Act of 1882 was the case of Nishimura Ekiu versus United States. And this was during a period of U.S. history wherein there was very intense discrimination against East Asian immigrants. And in this case, a woman immigrating from Japan was excluded on these new public charge grounds without very much basis. Really, we can infer that the basis for exclusion seems to be assumptions based on gender and race that the immigration official held about this woman immigrating to the U.S. But the Supreme Court upheld the exclusion and quoted the language of the 1882 Immigration Act, stating that if, on such examination, there shall be found among such passengers any convict, lunatic, idiot, or any person unable to take care of himself or herself without becoming a public charge, they shall report the same in writing to the collector of such port, and such persons shall not be permitted to land. So really, this law was, right from the start, used as a tool to exclude anyone who was considered undesirable in the opinion of the examining immigration official. One of the reasons the public charge grounds of inadmissibility was useful to the Immigration Service at this time and during the present is that it allows immigration officials to meet these exclusion goals, which may be based on impermissible grounds, because it was subjective enough to allow immigration officials to discriminate on the basis of race, class, and or disability without frankly stating that that is what they're doing. I think it's important to remember that the language of the public charge grounds uses the word likely. So someone is inadmissible to the United States if they are likely to become a public charge. So this is subjective and relies on the immigration officer's assumptions about who can contribute economically. Again, in the language from the Supreme Court decision, on Nishimura Ekiu versus United States, the Supreme Court says that the final determination of those facts may be entrusted by Congress to executive officers, and in such a case, as in all others in which a statute gives discretionary power to an officer to be exercised by him upon his own opinion of certain facts, he is made the sole and exclusive judge of the existence of those facts, and no other tribunal, unless expressly authorized by law to do so, is at liberty to re-examine or controvert the sufficiency of the evidence on which he acted. So what the Supreme Court is saying here is that this law hands over to individual immigration officers the sole and pretty much unreviewable power to make this determination that someone is a public charge. And again, this subjective determination that someone is a public charge.
Agents increasingly found new ways to discriminate against immigrants that did not fit their ideal physical and racial profile, and created a host of categories that labeled them unworthy of residence in the United States. Eastern Jews also suffer from eugenic practices when immigrating into the United States. They were considered to be of undesirable national origin and were forced to jump through numerous obstacles in order to be admitted into the United States. These obstacles included having to own proof of identity, medical documentation, and exit permits before a visa will be issued. In 1924, the Johnson-Reed Act already limited the number of immigrant visas that were issued per country. These quotas were designed to limit the immigration of people considered racially undesirable, including Southern and Eastern European Jews.
Speaking on the quota system limiting immigration in each immigrant category, when we say that the quotas were designed to limit immigration of people who were considered racially or physically undesirable, it was really very intentional. Language from the U.S. House of Representatives Committee on Immigration and Naturalization report, which became the 1924 permanent quota law, stated that we are conscious that the continued arrival of Southern and Eastern European immigrants in great numbers tends to upset our balance of population, to depress our standard of living, and to unduly charge our institutions for the care of the socially inadequate. If immigration from Southern and Eastern Europe may enter the United States on a basis of substantial equality with that admitted from older sources of supply, it is clear that if any appreciable number of immigrants are to be allowed to land upon our shores, the balance of racial preponderance must in time pass to those elements of the population who reproduce more rapidly on a lower standard of living than those possessing other ideals. This is very clearly racially charged language coming from Congress. And I will also mention at this time that a modified version of this quota system is still in place today.
As U.S. immigration policies continue today to call into question the disability status of individuals, the journey of the disabled immigrant will continue to be much difficult than of the non-disabled immigrant. The current administration immigration policies that are looking to demonize refugees, deter, and separate families at the border are reinforcing a system that has created more disabled individuals by exposing immigrants to trauma, abuse, and harsh detention conditions. In addition to these enforcement tactics, the current administration is putting in place more legal barriers to immigration of individuals who immigration officials believe may use public services such as Medicaid.
The current administration is in the process of actually expanding the public charge ground of inadmissibility. And the new public charge laws, which are of course designed by anti-immigration policy maker Stephen Miller, who is also the architect of the Muslim ban, child separation policy, and many other anti-immigrant Department of Homeland Security policies enacted by the current administration, explicitly considers disability to be a highly negative factor in the assessment of who will be inadmissible on public charge grounds, based on the assumption that people with disabilities are more quote-unquote likely to become a public charge. Again, this ground of inadmissibility is a useful tool for what would otherwise be unlawful discrimination on the basis of race, class, gender, or disability.